Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we were not trying to clickbait you when we said that this is a momentous day. Because one of the things we talked about as Attorney General Pam Bondi took over the Department of Justice is what could the United States Department of Justice do to help advance and secure our Second Amendment rights. And one of the things we said that they could do, because it doesn't really cost a lot of money and it certainly doesn't cost a lot of political capital, is you can get involved in already pending cases as an amicus party. Well, guess what, America? Yeah, the Department of Justice has done just that. And for the first time, and I do believe this is the first time in the history of America, yes, your United States Department of Justice has joined as an amicus party on behalf of the petitioners, translation, on behalf of the party attempting to advance and protect gun rights. We're going to share with you what the Department of Justice wrote because this is a big deal. So today, let's spend a few minutes and let's talk about a monumental day for gun rights and DOJ also. Okay, America, and I really am not trying to overstate this and fluff this up for anything more than what it really is, which is huge. It is huge because the United States Department of Justice today has filed an amicus brief in support of the petition for certiorari before the United States Supreme Court in the matter of Wolford v. Lopez. We've talked about that before. This has to do with Hawaii's crazy law that says you cannot carry on to private property unless you have express permission from the property owner. And since most people in Hawaii don't post guns are welcome sign, it basically has equated to an island-wide ban on concealed carry. Now, even though this case is in an interlocutory phase, which does not bode well for acceptance, the United States Department of Justice has filed an amicus brief in support of the court accepting review for it. And I'm going to share with you what the United States Department of Justice authored because this is going to sound like one of the briefs I typically talk about from Second Amendment Foundation, Firearms Policy Coalition, Gun Owners of America, NAGR, all of those organizations. You will literally think that it was authored by them. The issue, as the Department of Justice presents it to the Supreme Court, is this: whether the Second Amendment allows the state to make it unlawful for concealed carry license holders to carry firearms on private property open to the public without the property owner's express authorization. Now, of course, as an amicus party, you have to state why you have an interest in this claim. And the Department of Justice correctly states, the United States has a substantial interest in the preservation of the right to keep and bear arms and in the proper interpretation of the Second Amendment. I want you to think about that for a second, America. Let's put that statement up again. Did you ever believe, especially during the last 4 years, that you would ever hear the Department of Justice have this as their official statement? And take a look at how the Department of Justice frames the issue. After Bruin, 5 states, including Hawaii, inverted the long-standing presumption and enacted a novel default rule under which individuals may carry firearms on private property only if the owner provides express authorization, such as by posting a conspicuous sign allowing guns. Violations constitute misdemeanors punishable by up to a year in prison. Because the property owners do not post signs either allowing or forbidding guns, Hawaii's default rule functions as a near-complete ban on public carry. And the Department of Justice is quick to take the Ninth Circuit to task, which upheld this law, because DOJ states, yet in the decision below, the Ninth Circuit upheld the rule against a Second Amendment challenge. That decision warrants this court's review. Hawaii's novel default rule defies, indeed effectively nullifies, the general right to public carry that Bruin recognized. And then, again, like a Second Amendment advocacy group, the Department of Justice calls the state out as to what their true intent is. That is no accident. The structure and operation of Hawaii's law reveal that the law serves no legitimate purpose and instead seeks only to inhibit the exercise of the right to bear arms. And listen, America, there's a lot of positives to take from this. We're not going to make a 25-minute video and start dissecting all the language. But the Department of Justice is beginning to telegraph where they are going to go with some of these arguments that are being advanced in these civilian disarmament states, where we're bastardizing the in common use test and things such as that. Because DOJ is quoted in their memorandum as stating that near complete ban is flatly inconsistent with Bruin and the long history underlying it. Bruin recognized that an ordinary law-abiding citizen has a general right to public carry arms for self-defense. But ultimately, what the purpose of this brief and all the briefs are is to try to convince the United States Supreme Court to accept review of this case. And as I mentioned earlier, the case is in an interlocutory fashion, which the Supreme Court simply just does not like to take. And yet, knowing all of that, the United States Department of Justice is emphatic in arguing that this case needs to be taken and needs to be taken right now. This court should grant review because, as 8 judges correctly recognized, Hawaii's law largely vitiates the right to bear arms. But better yet, I think the Department of Justice kind of tips their hand as to who else on the Dirty Dozen list or who else on the medals podium might be next on the list, because you just couldn't help but notice this. Review is especially warranted because Hawaii is just one of multiple states that have enacted such laws since Bruin. Bruin identified 6 outlier states that have maintained the type of may-issue licensing regime that the court struck down. 5 of those states, Hawaii, California, Maryland, New Jersey, and New York, then reacted to Bruin by enacting the type of default rule at issue here. So America, is this brief going to make a difference? I don't know. We will find out. Again, trying to get the Supreme Court to accept a case that's in an interlocutory fashion somewhere before the end of the football game is very difficult. But is this a monumental day for Second Amendment rights and the Department of Justice? It absolutely is, because I cannot recall any time where the United States Department of Justice weighed in on a Supreme Court matter in favor of gun owners. And if this is in fact the new DOJ, and I recognize that many of you had serious reservations about Attorney General Bondi when she was named to that position, and I recognize where those reservations are coming from. But you have to admit that in the last 30 to 45 days, there has been some pretty significant progress. There is word of even more significant progress, and we are absolutely positively seeing a change in the playbook from what we are used to, even under previous Republican administrations. Okay, the case once again is Wolford v. Lopez. We're going to go ahead and link up the DOJ amicus brief down below. Like I say, you will think it has been written by a Second Amendment advocacy group. If you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information is down there in the description box. If you got an idea for a video we should be doing, you click on that link right there and you tell us all about it. If you want to subscribe to the monthly newsletter, that information is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe. So today we want to check out and see how secure StopBox really is. So we're heading over to one of the book clubs to have it tested by one of the most dangerous creatures known to man. That's right. I'm talking about the drunk suburban housewife.
You guys, your name's coming.
Oh, hey, ladies.
Oh, hey!
How's book club going?
Oh yeah, I have a shit ton of stuff.
You look like a Lolita.
No.
Lolita.
What is wrong with me?
Call me Steve, Jake. Ew. You look like a Hannah.
Taylor. No.
Yes.
No.
Yeah. With those lips, you're
100%
Lolita. Spicy.
Yeah.
Cuban.
Sorry.
Okay, ladies, got a little challenge for you here.
Oh.
Yeah. Okay, so listen, here's what I got. I got a $200 spa package to Willow's Lodge.
Ooh la la.
I got 2 days, 2 nights at Suncadia, $100 at Target,
Nice.
and $100 at Wine and More, because I know you can need that. So, any of you get into the box, it's yours. Have fun.
Okay, who wants to go first?
I can get in
Okay,
the box.
Beth. Get it, girl.
Come on,
Get it,
Monroe.
girl. Come on. Get that spa package.
Oh!
Yeah.
Come on. Ooh. Get it. Come on.
You gotta push all the buttons. You're doing the same thing over.
Come on.
I have to figure this out.
I just give up. I'm pouring more wine.
Give up?
Yeah.
I give up.
All right, well.
You didn't pour me any.
Close, but looks like they're all mine. Thank you, ladies.
What?
StopBox. Protect your family while protecting your family.